Good morning to all of you. Very recently, on 9th of this month, the Honorable Allahabad High Court once again brought into light that the arrest should be the last option. The arrest by police should be the last option, like the circumstances when the custodial interrogation is necessary. But it should not become unnecessary and unwanted. That means to say, the police should resort to arrest only in exceptional cases. The single judge bench, Justice Siddhant Verma, he passed the order while hearing the anticipatory petition of Sachin saini in a case under sections 452, 504, 323 and 506 IPC. Right, you can read this case as Sachin saini versus State of UP, wherein once again read that the arrest should be the last weapon, the last resort. So arrest should not be done in a mechanical way. At the same time, as a retired police officer, we know that for maintenance of the law and order, for bringing the crime under control, for teaching the goons a lesson, definitely arrest is the important weapon in the hands of police. But please remember, the judiciary will be thinking, not only the judiciary, even the common man will be thinking the other way. We are going to discuss that part also. Now, the case is registered under section 452, most important. That is trespass, committing house trespass armed with deadly weapons. Right? The advocate normally, as usual, the advocate stated that, Your Honor, this is a falsely, my client, the petitioner has been falsely implicated and he is apprehending that he may be arrested. Previously also a case has been registered against him. He is under the strong reparation that he may be arrested one time or other. Therefore, he is requesting for the anticipatory bail. Now, the Allahabad High Court relied on the decision, very famous case, Joginder Kumar versus State of UP in 1994, where actually they have dealt with the third National Police Commission report. In this case, you may be knowing Mr. Joginder Kumar. He was aged about 29 years by the time he was an advocate practicing in some area near Missouri. So on 7/1/1994, the senior superintendent of police called him. He went to the SP's office and he did not come back. His brother, suspecting something, he went there. Of course, the said Joginder Kumar was not found. Later, on 9th, it is learned that he was kept in Missouri police station. They went there, but they could not find him. Ultimately, they filed a writ petition before Allahabad High Court. Right? So this matter went to the Supreme Court level also. As his brother filed a writ petition on Article 32 before the Supreme Court, that is habeas corpus petition. It was disposed very clearly. They also stated, even though right from section 41 to 61 of the CRPC tell or has got given enormous power to the police, but you may be knowing, right from section 41 itself, what does 41 say? Police may arrest. There is no point in shall arrest. There is only saying that according to CRPC, police may arrest. That means it is not within a definite period that they have to arrest. They may arrest, they may not arrest. Nowadays, you may be knowing about 41A CRP notice that if the offence is below 7 years, definitely it will be suffice if they give notice under section 41A CRPC and they need not arrest the persons also. So, why all these things? Because Allahabad High Court actually at that time Supreme Court also discussed at length about the third National Police Commission report. So in this report, very sorry to say that The arrest is mentioned as one of the chief sources of income to the police. Second point, 60% of the arrests are either unnecessary or unwanted. And thirdly, it is a violation of the fundamental right, that is under Article 21, right to life and personal liberty. Why you are afraid of the arrest? Because your personal liberty will be curtailed. Therefore, you want to manage the police by giving some bribe or something like that. At the same time, the other party, they wanted to see that you are put inside. Of course, no financial benefit will be there, but they will have the mental satisfaction that they are able to make a person go to jail or get arrested. Right? So, this is the discussion. Third, National Police Commission report itself said, arrest may not be necessary in all times. The police should not do mechanical arrest if there is a necessity, particularly necessity like the custodial interrogation, if some property has to be recovered, if some disclosure has to be made, if something has to be, that is where the police custody plays a major role. So under such circumstances, yes, definitely, police has got the power. You can't curtail the power of the police. Yes, they can arrest, but there should be some rigor in the arresting. When, what, whom to arrest and whom not to arrest, when to arrest and when not to arrest. All these things should be known to the investigating officers. So normally the court may be actually commenting on the police that it has become a tool or it has become a misuse by the police. But definitely for maintenance of law and order, arrest is compulsory, arrest is necessary. Unless the hooligans, unless the bad fellows, unless the rowdies are brought before the court by way of arrest, normally they will get emboldened and will commit more number of crimes. Definitely arrest is necessary, but at the same time it should be rational, it should be proper, it should be to the time. Is it not? So unnecessary arrest should be avoided, and therefore Allahabad High Court said, yes, in this case what happened is Sachin, he was granted anticipatory bail. So what happened is the court directed that in case of arrest, he should be released on bail with two sureties to the satisfaction of the court of Missouri or something, concerned court. I don't know the name of the court with the sureties. So this is the normal bail order. Why I am emphasizing this is, as advocates we have to know that actually the arrest is not mandatory. Arrest is only optional. The police, section 41, please read section 41. Police may arrest. There is no saying that police shall arrest. Even if it is a murder case, police may arrest or may not arrest. That is the power within their hands. Right? So, if any unnecessary, unwarranted arrest is there, you can raise this question with the case law as well as very famous case law of Jyotirmay Kumar. In that connection, I want to tell you, yes, now they have filed a writ of habeas corpus and the matter came to the Supreme Court, and the senior superintendent of police produced the so-called Jyotirmay Kumar advocate before the court on 14/1/1994. After 1 week, he was produced. And the senior superintendent of police stated that actually this advocate was wanted to assist the police in the investigation of a case. He readily obliged, he cooperated, and with his assistance only, we are able to crack this case. That is the version of the senior superintendent of police. Now, of course, it was not believed. Anyway, since he was set free or let free, since no arrest was there, they are happy. But you see how much of actually agony the family of the arrested person faces. Please remember this. So please, you have, as police officers, you have got ever power to arrest a person. But use it sparingly, use it rationally, particularly in this period of the corona. Very recently we had a bad incident of the Telangana police coming to Andhra Pradesh, Ongole, for execution of a warrant in a negotiable act check bounce case, and the politicians they are coming and taking a lot of nuisance. It has come in the press also. Anyway, it's a political issue. Let us not bother about the same. But the incident, please note it. Because, so what action to be taken? Right? Oh, whatever it is, please remember that arrest is not mandatory, arrest is not necessary. Arrest should be the last resort. So Joginder Kumar case was dealt with by no less than Honorable Justice Pattaswamy, who is the propounder or who is responsible for the judgment of Aadhaar. Right? Okay. Thank you very much.